let's do a quick TLDR. So I broke down the defense motion. I did not break down the Commonwealth's response to the motion. We'll hear the Commonwealth's response today. The Commonwealth is going to say, not on us. So some form of not on us in writing is what you're going to get from the Commonwealth's response. The defense motion today is regarding their expert fees. Remember, the court was holding aside today for a hearing if an evidentiary hearing needed to happen for the tech expert. The court said, I'll decide this matter without a hearing. I broke that down on Tuesday's episode of The Emily Show, which lives on the Quick Bits channel. So the Commonwealth is going to say some version of this isn't on us. The defense is saying, look, we flew our expert out to Canton. We did it at our expense. We were led to believe that this information existed in its original state on the DVR at Canton PD. And the defense wanted to download it. The defense says, we keep getting bits and pieces of video. So at some point, you saved video and you're just like dripping out all these little pieces of video. We should have access to all of the video. It should have been preserved. It should have been turned over. We think it's exculpatory. The defense, I have not seen their motion to dismiss filed yet, but it is due this week, and we will see a motion to dismiss being filed regarding whether or not this is exculpatory, whether or not this is Brady. Remember, you can have discovery issues that are not Brady issues, and if you have discovery issues that are not Brady issues, they can have some different remedies than if they are Brady issues. Brady issue is very fact-specific, and you will remember when we went through all of this in New Mexico, the court was very clear that something being impeachment of a witness is not necessarily exculpatory, and there's a lot of case law around what is and is not exculpatory. So there's more of a fact situation that we need to delve into, and I just don't have enough of the facts yet to dive into that. But my gut is like, well, I need to know more, and I need to hear more about this. Today, we're going to hear some of it, and then we will get when the defense files their motion to dismiss and or when the motion to dismiss is filed with a response from the Commonwealth, then we will go over it together.
The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher.
Here's the timeline that I am picking up. That the defense sent their expert out there. The expert got out there and they're like, there's no original footage on the DVR. That is the system that runs all the cameras. The logs are gone. There's no original footage on the DVR. And then they asked all the questions. Their expert is like, did you save it somewhere? And we read the defense motion. If accurate, which we don't have reason to believe it's not, the defense said, our expert said, did somebody download it somewhere? And then, no. Did somebody do this somewhere? No. Okay, well, where is it? And they're like, IDK. And then after the defense expert leaves, Brennan goes to the police and is like, hey, so where is the footage? And then they find something? What?
And that has been overwritten.
Okay.
And there is no information on that.
Okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and the defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29th, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
Here's what I think we've just learned. Some dude, now retired, saved some select videos, but all of them weren't saved, and everything's been overwritten. So like you get what you get and you don't get upset, which is not how discovery works in a criminal case. This is decision and order on defendant's motion to recover expert-related expenses from the Commonwealth. After hearing and reviewing the pleadings, the court credits the affidavit of Special Prosecutor Hank Brennan, paragraph 6. Okay. Quote, Attorney Jackson expressed concern that the materials may no longer exist on the police department DVR and VR given the time that had passed since the event. I agreed with him and told him I had no knowledge whether the materials still existed or were overwritten given the passage of time. Well, we can see why the court's denying it then. In light of the averment of ADA Brennan and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennan discussed his concerns regarding the likelihood of the video existing, the motion to recover costs is denied. Further, though Attorney Jackson argued for sanctions for an alleged violation of Massachusetts Rule of Criminal Procedure 14, there is nothing in the written pleadings raising that argument, and the issue is therefore not currently before the court. So moot, but it will come up, I'm sure, in a separate motion. Defendant's motion to recover expert-related expenses is hereby denied. I'm not sure all of you are going to feel good about that ruling. However, the thing that is going to stick out to the court in that is that when Jackson was pressed on, did you have this conversation with Brennan, where both of you expressed concerns about the existence of the video, he did not deny that and did not say, no, Brennan told me that it was there. The defense saying we want to see anyway is a choice. That's not them being misled. So if Brennan had said, which is what the defense originally argued, if Brennan had said, yeah, come out and get it, sure, of course, and they got out there and it wasn't there, that is a different circumstance than Brennan saying, I have concerns that what you're seeking does not exist, but if you want to give it a try, we're going to allow you access. We've not told you it's there. I don't think it's there. I have concerns that it's not there. And giving the defense that heads up means it's a choice, not that they have been induced to do something where Brennan had told them, yes, it's here, come get it. It was, we don't think it's there, but you're welcome to come check if you choose to. That's what this issue comes down to. At the end of the hearing today in Massachusetts, we did learn some interesting new information. First, the court took up a number of matters in just a little over an hour today in Massachusetts with regard to the Karen Read case. The biggest matter that the court took up today was the defense's motion for expert expenses, where the defense argued that the Commonwealth led them to believe that there was information at Canton PD on the original DVR system with the different video cameras from the overnight when Karen Read's SUV was brought into the Sally Port at Canton PD, and they wanted to download that video with its metadata from the original format. And then when they got to Canton PD, everybody was like, this isn't here. And the only reason they spent the money to send their expert is because they believed, based on conversations with the Commonwealth, that that existed. in the Commonwealth's response today in court, and I have not reviewed with y'all their written response, but in the Commonwealth's response today in court, the Commonwealth said, and the defense did not deny, that Hank Brennan, the special prosecutor, said, I have concerns that this does not exist on the DVR. I think that this has been overwritten. I don't think this is still there. And Alan Jackson said, I have those same concerns that this is not still on the DVR. If that is true, then did the defense make a choice in saying, we're going to send our expert anyway? And when we finish with the hearing, because law nerds are bae, y'all let me know that the judge had already ruled today, which color me surprised, because this judge does not rule regularly from the bench, but in the last 2 hearings has ruled very quickly in time to when the hearings have happened, which is not what we saw before. So Judge Cannoni denied that today and said very specifically it was based on ADA Brennan's representation that ADA Brennan expressed to Jackson concern that that did not exist and was not there, and agreed with Jackson that it likely did not exist and had been overwritten. And therefore, again, the defense made a choice. It's not, oh, it's here. The defense shows up and goes, well, where the fuck is it? It's, I don't think it's there. You don't think it's there. But if your expert wants to come access it, we'll give you access. That's your choice on how you decide to prove your case. But what we did learn that is going to be an issue, and perhaps a large one for a different day, is that not only did the defense expert go out to Massachusetts and wasn't able to download anything from the original DVR. So what we learned today new is that after the defense expert came out to Canton PD and couldn't download anything, Brennan went and had a conversation with somebody who's retired. And that when Brennan had that conversation, they found that a detective had downloaded selected videos and had saved those on a hard drive and perhaps some type of iCloud or cloud account. So there are some selected videos that were downloaded, and Brennan said very clearly in court, I don't believe that there is an exhaustive and entire download of video from the Sally Port from that relevant period of time, January 29th, 2022. We don't think that exists. And so someone downloaded selected videos from the Sally Port, and the defense doesn't have all of those yet. And that is wild to me. So we are going to see the defense making a motion to dismiss. We might see the defense making a Rule 14 discovery motion or motion for sanctions together. So we're going to see more motions about this. Today was not the day to fight all of those different battles. Today was just about the fees that the court denied. But there's a lot more information that we need about who chose to download selected videos and then save them on some hard drive or somewhere that weren't turned over to the defense before the first trial. Where did all this video just live? So for all of you that are going to ask, and many of you will, how is this any different than Santa Fe police putting ammunition under a separate case number and being like, oops, we didn't think it was relevant to this case? There is so much more information we need. I'm looking forward to seeing the motion to dismiss and response to the motion to dismiss to learn more about this. It seems that when Brennan came onto the case, Brennan discovered more video that had never been turned over and turned that over. It seems that when Brennan came onto the case, he also discovered that there was discovery that the Commonwealth didn't have. And was like, where is this information? Including information from the defendant's phone that they are going to have before the next trial that the Commonwealth didn't have going into trial. Like, the Commonwealth didn't even make sure they had all their own discovery. And the Commonwealth was arguing again that they wanted more discovery about the ARCA experts. Though Brennan said so-called experts, which definitely got the ire I think it deserves, because the ARCA experts I thought were fabulous. And so-called experts, you can try to throw shade, sir, but please. We also learned that the Commonwealth has turned over voluminous, their words, new discovery to the defense in this case ahead of the second trial. New experts, new expert reports, new full files. So this retrial seems like it's going to be a very different case, including, it seems, a completely new accident reconstructionist and a new accident reconstruction process. So the defense got voluminous new discovery today, beginning of February 2025, ahead of an April 1st start date for jury selection. So much is going to happen in this case between now and April when this trial starts, and this retrial is going to be a completely different case. I'm still stunned at the things we learned today in court, especially about all of that video that wasn't turned over. Is there arguments to be made about dismissal? Yes, we'll talk more about it. We'll talk about whether this is exculpatory or whether it's just information that can be used to impeach witnesses. We'll have that discussion. We'll talk about what the case law, because it's going to be in these filings, the case law in Massachusetts regarding a motion to dismiss, regarding Brady, and regarding whether or not there are discovery violations here. We're going to see all of those arguments. And as the attorneys make those arguments, we will have enough information to argue it, because right now I don't have all the information. I have a lot of questions, and I do not have confidence that there aren't some very large problems here. What will happen with those, we will see. But this is advocacy. I want to see what both sides argue with regard to the motion to dismiss and the timeline. And though there are times I do not appreciate Brennan's snark at experts that I liked during the first trial, because, sir, how dare you? Sir, how dare you? But I also think Brennan was fairly upfront with regard to how the discovery shit show happened, and seemed to be very like, this happened, then this happened, then this happened. This is what I told the defense. This is what's happening now. He didn't seem to me to try to justify or excuse it as we got to the end of the hearing, but tried to explain the process he went through. The Commonwealth should have gone through that process 2.5 years ago. But at least he said, this is what happened since, this is what we discovered, these are my concerns. That can be kept out at a new trial. That could be Brady. The defense is saying that it is, but the defense hasn't even seen all of it yet, so they're not going to know if it is or if it isn't. But there's a lot more to this case as it gets ready for trial. That the fact that the Commonwealth's like, we don't have all the discovery from the defendant's phone. So why are we filing this case then? How are we at a second trial when they don't even have all the information from the defendant's phone? What is happening? This case is wild to me. Wild to me. This shouldn't be happening. This shouldn't be happening so late in the game, but it is, and we will see. I'm going to cover all those motions when they get filed. I want to know. I want to know. I want to know. I'll say it full-throatedly. I have so many fucking questions. And trials in 2 months. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.